Good afternoon, everybody, and welcome to our presentation today. It's called "What the Heck is Happening in California?" A phrase that we throw around quite often here at Carlton Fields, and that we thought we would share with you in the course of today's webinar. But in all seriousness, it's a great topic, and we're gonna drill down on the latest in California privacy law, both in how it relates to California and what it may mean in terms of a harbinger for other jurisdictions. So we're looking forward to spending the next 60 minutes with you. And without further ado, we can move to the next slide. By way of introduction, I am Joe Swanson. I'm a shareholder in the Tampa office of Carlton Fields. I am the practice group leader for our cybersecurity and privacy practice group. And I'm joined this afternoon by two of my colleagues. Christina Gagne is a shareholder in our Los Angeles office, a member of the Cybersecurity and Privacy Practice Group who focuses her practice in particular on developing and building out compliance programs for her clients. Steve Blickensderfer is a technology attorney in our Miami office. Steve also is a member of the Cybersecurity and Privacy Practice Group. He works with public and private companies to develop and implement their privacy compliance programs, and Steve is also the co-chair of the IAPP Local Knowledge Net chapter in South Florida. But just a reminder to everyone, you should have seen this when you logged on this afternoon, but today's session is being recorded. Next slide. We've got an action-packed agenda for the next 60 minutes that, as I mentioned, will be focused on California certainly, but also some discussion of what it may mean for other jurisdictions as we look forward to 2021. We'll be addressing the new Attorney General and the new law itself, diving into what the California Privacy Rights Act is and whether its enactment makes the CCPA a lame duck regulation. CCPA is the law that all of you are familiar with and that we have given webinars on over the course of the last 12 months. We'll talk about enforcement of the CCPA, the wave of private right of action litigation, and then wrap up with questions and answers. Although please, during the course of the presentation, we want to make this as interactive as possible. And if you do have questions, feel free to share them with us through the chat function, the Q&A function, and we will handle those when we can. So without further ado, I will hand it off to my colleague, Christina.
Well, good afternoon. There have been some major changes in California, and I have to say the day after this ballot initiative passed overwhelmingly by California voters, I was getting a lot of emails which were much more colorful about what happened with the CCPA and how California, after only seemingly 2 years, now has a new privacy regime. But just, this is not something that came out of nowhere. The CCPA was a legislative compromise. There was the threat of a ballot initiative 2 years ago. The legislature sort of rammed through the CCPA, and through, legislative amendments and compromises, we got to, what is currently the CCPA. And I say that because all of last year, there were modifications that were released to the CCPA. The enforcement window was moved back due to COVID. And then we arrived 2 months after the enforcement window in November 2020, and all of a sudden there's a new law. So I know a lot of businesses are left with questions. It doesn't seem like the CCPA, has been enforced so far. So why worry about the CPRA? And I think, that might be a logical question, but this is all happening at the same time of other movement in California. And that other big movement is a new Attorney General. Attorney General Becerra has headed to Health and Human Services. And so now we are in a huge flux in California of who's going to be the new Attorney General. One of the things that I like to ask, as AG candidates are getting vetted or discussed, and even some of the insider baseball, is do any of these candidates, have a background in consumer privacy? Is there something through their experience as a prosecutor or in private practice or as advocates, which many of the candidates are advocates for, not consumer rights, but for individual rights in their capacity right now? Do any of them have a background in consumer privacy? And right now, no one who's being proposed or pondered or the rumors, really has that background. That being said, if you go back, 8 years when Vice President Harris was the Attorney General in California, she really picked up consumer privacy and made that one of her hallmark issues as AG. And that's really when we saw from about 2012 to 2015, a focus on consumer privacy, whether that was the mobile app accord that was arrived at with some of the big tech companies, whether that was providing resources to a privacy agency to actually engage in enforcement actions, or focusing on ancillary privacy issues. There was definitely a commitment. So this new AG, whether or not they have that background in consumer privacy, certainly can make that a priority. In addition, and as we'll discuss later, in this conversation, the CPRA, we'll be going through some elements of it in a couple of moments, actually establishes a new agency. So one of the key things that I think was missing with the CCPA, for better or worse for business, was there was no agency to go to directly to ask questions, to get guidance, to create a sandbox for companies, or to enforce. And I believe now with the CPRA, we are going to have that. And so what happens from now until, 2 years from now, when the CPRA goes into effect, I think will be a buildup to, the launch of that agency. So I think the big question we want to discuss today is, how is the California privacy law landscape going to be over the next 2 years? What do we expect from the AG's office? And as businesses who, may or may not have done CCPA compliance and laid some groundwork, what can you do in the ramp up to the implementation of the CPRA, whether it's your existing compliance work or new work you need to undertake. Next slide, please. So what is the CPRA? And we kept discussing this as a practice group. It's the most new privacy law because California has a tendency to outdo itself when it comes to consumer privacy. California has had consumer privacy laws on the book since 2003. There just were no enforcement teeth behind it. Then there was the CCPA, now with the CPRA. So essentially businesses have probably about 2 years to get their compliance programs put together. Much of the CPRA is enhancements to the existing California Consumer Privacy Act, but it does introduce a host of new obligations, consumer rights, and actually target specific practices and specific verticals, within the privacy space, whether it's ad tech or other business models, much more ardently than the CCPA did. I also want to make a point that, I just thought of last night as, I was thinking about things I wanted to share today. These ballot initiative itself also specifically put in provisions so that the legislature could not chip away at the CPRA. So the history of the CCPA was legislative compromises. The bill became much less onerous over time. That will not be able to happen with the CPRA. So I think, again, whether you like the CPRA or not, the state of play, I think, is a lot more in place with the CPRA than it was with the CCPA. So, for those businesses that are looking to invest compliance dollars or don't want to make decisions where they feel like there are just going to be compliance redundancies down the line, I think the CPRA and the static nature of it, will be a lot more useful. But let's jump into some key features. We're not going to bog down in a lot of the details today, but we did want to give you some highlights of things to start thinking about. Next slide. So one of the big, advantages of the CCPA or sort of the license that many businesses took with the CCPA was a dependency on a cure period. So, many businesses were looking to the AG's office to send out a round of enforcement letters, and either they would be a recipient of that letter that would point out what deficiencies they had against the CCPA, or they would see businesses in their industry receiving these letters, be able to identify, what issues the AG's office was particularly focusing on and adjust accordingly. And so that 30-day window, which I do want to say, if you are building a compliance program, that is a very tight window to build out a compliance program generally. And so I just want to caution that I would not wait until December of 2022 to start doing your CPRA compliance. This is something that should be a layered approach over over time. And for small to mid-sized businesses, there can be, resource constraints, creating that timetable now and that roadmap can be exceedingly helpful. But what the CPRA does is it takes away that cure period. So if you were going to act in reliance on or sort of did half measures to comply with the CCPA, that will not be available anymore. And again, as a compliance attorney, I would never endorse a business waiting on a cure period or getting a letter to do anything, but that simply is not going to exist. And one of the reasons that this was pushed by the individuals and organizations that were behind the ballot initiative is they just did not think that the AG's office was going far enough or that the CCPA went far enough to address privacy issues. And if businesses were simply put in a position where they had to be reactive, they didn't believe that consumers were getting the rights protection they deserved. So I just want to point out that if you are or were waiting on that 30-day cure period, that will no longer be there in 2 years. That being said, a wave of letters went out from the AG's office, back in the summer. We were discussing, what happened to all of those letters. So much has happened in the last 5 months. So I don't want to posit sort of like what happened in terms of, were companies followed up with or what the posture of the AG's office was. What I will say is I think that once the dust settles with the new AG, I think that we will see a wave of letters go out or renewed focus on those companies who initially, were part of those inquiry investigations. I also want to note that, this cure period and the absence of it, only applies to data breaches and the private right of action. So, those are the pieces, though, that I think, have been overlooked with the CCPA. And so I'll turn it to my colleague, Steve, to address the private right of action more thoroughly.
Thanks, Christina. And just to kind of piggyback on what you're talking about in terms of, grace periods, cure periods for compliance, when the AG sent out those letters, there's kind of an initial back and forth that's anticipated in that process. It's not really written in the law that, as a business, you'll have an opportunity to fix things. And so just a caution out there, don't rely on the expectation that you'll have an ability to fix a problem, although that's kind of how the process is starting to work out. But that cure period that is actually in the statute is, as you noted, strictly for the private right of action, and the CPRA is going to do away with that. That's really one of the big changes that Christina just mentioned. And also another big change, which expands the right of action in a big way, is the inclusion of certain data that's going to trigger a private right of action under the CPRA, the CCPA. And that is to include, within the definition of personal information, email addresses, along with a password or security question that would allow for access. Now, in this presentation, we're kind of assuming a certain level of knowledge about the CCPA, but just to bring everyone up to speed, that portion of the CCPA that allows for private right of action specifically calls out a different part of the California law about what the definition of personal information is. And the big picture here is the CPRA expands that to include emails and passwords or security questions. And the reason for this, the author for this and the CCPA, Alistair McTaggart, kind of went on the record saying, this is to address kind of a piece that was missing in the first iteration of the CCPA, and that is most data breaches that lead to identity theft involve, the disclosure of email addresses and ways to access accounts. And so the big picture here would be to redact and encrypt this type of data, in addition to the other data that is defined as being personal information for purposes of data breaches. Next slide. In addition, there are a number of new rights that are gets grafted into the CPRA that businesses are going to be needing to disclose as rights that they offer to consumers, and also that they need to comply with. And one of those rights is the ability to opt out of cross-context behavioral advertising. Why that particular type of advertising? That's just because it was seen as a type of advertising that the CCPA was intended to prohibit or allow for people to opt out of, and it wasn't doing that. Why? Because there were some language in the CCPA about advertising, as that being a business purpose. And so now the CPRA literally puts a line through that and says you cannot cross-contextual behavioral advertise, and that is basically advertise to people specifically based on their surfing and behaviors online, inferring what they might like and targeting ads to them. Again, users have the right to ask if you're doing this about them and to opt out of that. That's kind of the new thing, and it's going to force ad tech companies and companies that heavily rely on ad tech and advertising online to figure out A, if they're doing it, B, to what extent they're going to need to disclose that and limit the ability of consumers to not be subject, but to allow for that to happen for purposes of complying with the CPRA.
Hey, Steve, just a quick question for you there, and it picks up on something Christina observed earlier, and that is that these compliance measures take an inordinate amount of time, as we've seen in working with our clients in the CCPA and the GDPR and other engagements like that. Would you agree that through your work, working with a client to institute a process that allows and facilitates a request to opt out is one of the most onerous, tricky processes to get in place with a company? Because it's one thing to put a website notice together that says we collect X, Y, and Z, and here's generally who we share it with. That's relatively straightforward. But working with a client to determine whether they engage in this advertising in the first place, and two, putting in a mechanism to fulfill a request to opt out is a labor-intensive project. Wouldn't you agree?
Yes, it requires getting a real handle on the flow of data through, beginning to how the data is kept and who else has access to it. If the business doesn't have their hands around that, it's really hard to demonstrate compliance with a request to opt out. And very recently, the AG of California had tweeted on Data Privacy Day about different, the rights that you have as a consumer, including the right to not have your information sold. And as a business, you need to comply with those requests, however they're made. And one of the new ways that we're seeing that was recently created was something called a global privacy control. And that's something that lots of web browsers like Brave and DuckDuckGo and other organizations that are trying to help users and consumers effectuate their requests are basically creating like the new version of do not track signal that is sent out to the ad tech ecosystem. Hey, if you have this person's data, they no longer want you to sell it, to transfer it to others. And so how businesses, in order to receive that and to act on it, requires an investment of time to really appreciate how marketing is using data in recent campaigns. And not only to kind of catch up and figure out what's going on, but to also maintain it over time, to build in controls to allow the various departments to know, hey, got to get privacy involved so that we can get a check on this particular thing that we're trying to roll out. So I don't know if we've lost Christina, but I was prepared to move on to the next slide. So this another subset or another big picture takeaway for the CPRA is the creation of a new subset of data, sensitive personal information. Now, big picture, the CPRA in many ways is bringing the CCPA and U.S. privacy laws in basically up to the GDPR. And again, I keep going back to McTaggart's public statements about the CPRA, so we can all kind of get an orientation of where this is coming from. Is that, well, if it's good enough for Europeans and they're enjoying those privacy rights, we should enjoy those rights too. And so that includes basically recognizing certain data sets as being sensitive information and the use of that information being restricted, just like it is under the GDPR. So if you're a business that has a global privacy compliance program, use of sensitive personal information in under the CPRA looks a lot like the restrictions on the use of sensitive information under the GDPR, including the installation. Well, this is new for the for those who are doing the GDPR, but in addition to the other stuff you have to do, businesses need to install a link, just like the do not sell, but now it's a do not share my personal information. You can combine the two and make it a do not sell or share my personal information. But just lots of different little things that need to be done in order to properly handle this type of information. And the beginning step of all of it is understanding whether or not you even have this type of information. And I'll actually transfer over to Christina for the next slide.
So one of the things I wanted to highlight is one, the categories of information. Some of this information, many of you may not be collecting, but some of it you are probably collecting commonly in transactions. The one point I wanted to make with this as a backdrop, though, too, is that yes, we're moving closer to the GDPR, and in one way that we are moving closer to the GDPR is consent. So one of the things that was absent from the CCPA was a definition of consent and sort of going through what meaningful consent was. The GDPR, one of the core tenets is consent, and whether or not, an entity, a business is obtaining meaningful consent. I think that becomes even more important if your business is transacting personal information that now qualifies as sensitive personal information under the CPRA. So this slide outlines some things that I think probably do jump out as things that you might generally categorize as sensitive personal information. If we can go to the next slide. You'll see that there's a couple other categories here that may not jump out to you as something that you might consider sensitive just by sort of a colloquial understanding. So personal communication such as emails, so I think having appropriate email security and storage and retention policies, genetic data, biometric information. These are two very hot areas in technology right now. And while we've seen a emergence of state level laws dealing with biometric data, Canada right now is also deliberating something. This specifically targets biometric data. So, California, was a jurisdiction, that had a law relating to this. But when you see this emerge in multiple statutes, if your company, is collecting biometric data, and sometimes that could be employee verification, that can be through means that are not a core part of your business model, but maybe you are relying on third-party vendors, or you have some sort of technology that you're implementing in the business that does touch biometric data. And finally, information related to sex life and sexual orientation. These three bottom categories, are wholly applicable to health tech and other verticals that are emerging who I think it's easy to say, these things don't apply to me, when in fact, I think we're going to find that they will. So it's just important to understand that, these are categories to watch out for, whether or not they're part of your core business processes. You might have things you do internally or vendors that you rely on to manage this information. It's very important to make sure that's being managed effectively. And I'll turn it back over to Steve.
And before I leave those categories of sensitive information, just to kind of give you a sense of how you kind of need to go back and double check your work from, say, GDPR compliance efforts. Precise geolocation data is among the category of personal information that you need to now make sure you're handling properly. And it actually defines precise geolocation data to mean data within a certain geographical range. It actually measures out the radius of like 1,850 feet. And so then you need to kind of check to make sure that any geolocation data you have, how specific, how close to the person do you get, and check it against the definition under the CPRA. So that's just kind of the minutia that you might need to get into, which is all the more reason not to delay compliance efforts into 2022, for example. Okay, so the two rights that we have listed here on this next slide are the right to correct and right to data minimization. And those who have demonstrated GDPR compliance for their companies, these are rights that are recognized as those that are enjoyed under this GDPR as well. So businesses need to disclose the right to correct and honor it using commercially reasonable efforts. What does that precisely mean? We don't know. Maybe we'll see regulations down the line that define exactly what those efforts might be. But we do know that these compliance efforts do not stop with the business. They flow down to service providers and third parties, and we're going to get to that in another in a little bit. And for data minimization, again, this is like a core privacy principle that we're seeing influence the CPRA, and that is that businesses will not process more than they need to, not collect more than they need to, and that their handling of data is necessary and proportional. Again, this is an echo of the GDPR found in California's new law. Next slide.
Steve, a question for you just on that, and it's probably pertinent to the next slide anyway, but this idea of data minimization and conducting a necessity and proportionality analysis, that kind of show your work idea was absent under the CCPA, but as you noted, was present in the GDPR and is now going to be present in the CPRA. What are some examples just that, what does it mean to show your work and actually, have some evidence that you fulfilled this data minimization obligation or the necessity and proportionality provision?
Maybe the most obvious ways of doing that would be through like a processing impact assessment or a data protection impact assessment. They go by different terminologies depending on which law we're talking about, but a privacy impact assessment basically says this is what we want to do or what we're about to do, and analyzes the actions that the business is about to take on through the lens of privacy. How will this impact the individual? Can you maybe more narrowly tailor the type of data you're going to collect and use? Can you shorten the time you keep it? Do different things to maybe minimize the impact that a potential exposure or unauthorized disclosure of that information may have. Who's going to have access to that data? That's the kind of analysis that goes through a impact assessment. And so that's the kind of record you create internally and you kind of keep and you log. That way, if a regulator wants to talk about a particular type of data sharing or action, you can show them the impact assessment that you did to help to demonstrate compliance with the necessity and proportionality of the regulations.
Yeah, and as you do your data mapping, if you've ever done it for the GDPR or are planning to do so, and now as you do it for the CPRA, necessity and proportionality, should be one of the things that you're checking every single piece of data against. So just like you would check to see sort of, how you're using it, whether or not there's a legal basis for use, you would also want to ask the question, that is this necessary and is our use proportional? So that's something you can integrate in there. The other layer is with risk mitigation. So, you might find that a piece of data, meets this necessity and proportionality analysis, but you might find other risk factors. So, I would say whether you're doing your data mapping, which will educate sort of all your data points in the data lifecycle, or you're adding on the second layer, which is the risk mitigation layer of actually analyzing risk of specific uses of data. Those are two ways that, you can show your work. I think finally, as it relates to a consumer request, somebody could allege, a variety of different issues against your use of data, or they're, alleging your misuse of data. So the other way to show your work is to make sure that you actually have clear outline processes in place, so that if you do get requests and people are asking this particular question, you can show, how you came to the determination about this.
Christina and Steve, one other question for you there, just kind of wearing a litigator hat for a moment. Whenever people start talking about creating records of things and impact analyses and risk analysis, it makes the litigators nervous about a written record, which may have all the salutary benefits that you guys have just outlined, but could, of course, be used against an organization sometime in the future. Say if there's a litigation or a regulatory enforcement proceeding and some kind of a document request that would seek those materials. I don't think you would ever have, in the absence of any pending litigation, a work product claim to those materials. Maybe an attorney-client privilege claim, although it strikes me that there's a legitimate argument that this work is being done for a business standpoint, a compliance standpoint, may or may not be privileged. Maybe the only thing to note on that at this point is just, be careful what you commit to writing and try to balance the very good reasons to have a written record with the idea that, you never know how this is going to read a year from now, 2 years from now. Any practical guidance you have there is probably worth mentioning as well.
I was just going to say that's a cutting edge issue. And I don't think that's something we've seen in Europe, because they're just, frankly haven't been as litigious under the directive, perhaps when those records were being created, and not yet under the GDPR. But that's definitely something to consider as privacy regulation is requiring the creation and maintenance of records to keep track of what your program is doing. So I think that's absolutely something to keep in mind.
That being said, I think that, and this is one of those issues that I think we are going to have to see what happens as the private right of action is availed more frequently. And other states are also going to have this issue. I mean, other states are taking, their guidance from the CCPA and the CPRA. But from an enforcement perspective and working with regulators, I believe it's more of a shield. So if you're immediately able to say, here's my homework, we did exactly what we were supposed to do, you're in a much better position than if you don't have anything because you were avoiding some, litigation that may or may not happen. So, I think that this is an instance where, yes, there could be some risk from a litigation perspective, but, with regulators, and I'll give you an example, I've had clients who have received letters from both regulators here in the US as well as in Europe. And they're like, how did I get on their list? Like how did I get their attention? I'm such a vanilla business. And I come to find out that, through the process that they were a vendor to someone who was under investigation. So, but they were able to show their homework, show that they actually had a compliance program. They were doing what they were supposed to do. And so why would the regulator keep, paying attention to this? It doesn't make any sense. They have a core enforcement priority. And if someone doesn't fit into that enforcement priority, it doesn't make sense to waste what are limited resources. So, I will say that, while, and there's a case that was recent, in data breach, I know that we all are familiar with it, but just to give a little background, expert reports and forensics reports, like there's a big question about those right now. And so this is not something that's, esoteric and it's not happening in real time with these reports and things that lawyers and others may be producing for companies. That being said, though, the absence of these materials, if they're required by law, and some of these laws specifically require them, others basically by the tenets of the law de facto require them. If you're going to get a regulatory inquiry, again, you can't in 3 to 4 weeks put together everything that you were supposed to do to comply with the law. So surely there's a balancing act, but I would say that, if you don't want to deal with regulators, then, do your homework, have your compliance handbook together and be ready to go to answer questions effectively.
And before we leave this slide, I just wanted to mention 3 other rights that are created by the CPRA, the right to access information about automated decision-making, such as the cross-behavioral advertising that I mentioned before. That includes the logic involved in such decision-making and the descriptions of the likely outcome. That could be a business's secret sauce. And so you need to consider whether or not these new requirements have what kind of impact that has on the business. In addition, consumers have the right to access, which they had before, but it actually extends beyond the 12-month look-back period, which might be a shock for some businesses. And there are some outs if it's, quote, impossible or involves a disproportionate effort. So don't know what that means yet, but I'm sure we'll have some people testing the limits of that. And also the right to know about data retention. Again, this is a GDPR enjoyed right that now we're seeing imported into California privacy law. Next slide.
Data retention being a corollary of data minimization, right? And just this kind of, if you step back and look at what are the animating features here, and this really wasn't present in the CCPA, but it is in the GDPR, it's let's try to tamp down how much data is being created and maintained, right?
Always a helpful question is, do we even need to keep this information for as long as we're already keeping it? Which is something that businesses weren't really asking before because it wasn't as much of an issue, and it now certainly is an issue. If you don't need it, consider just getting rid of it because it could be a liability. In addition to all of those rights, we have vendor changes and vendor contract changes that we're seeing in the CPRA, including a new covered entity called the contractor. Now, the creation of the contractor is really it's a minor thing. It's really not that big of a change. There was a third party under a written agreement under the CCPA that was not a service provider. This appears to be now the contractor. And a service provider, as now revised, defined under the CPRA, is that vendor that's acting on behalf of or at the instructions of the business for purposes of processing data. So kind of narrowing the reins on the service provider, creating this new general category of contractor retained by the business that might be touching personal data. And then you have third parties. All of them require a contract of some sort. And so at this point in like the vendor compliance, CCPA compliance process, most businesses have their contracts in place with their vendors, or have pretty good direction in terms of what they'd like to do with their main vendors, their service providers. But you still need now a contract with third parties. And these contracts need to say that the third parties shall not sell personal information, or that they will honor limits on the right to sell. And that if, in order to enforce or further demonstrate compliance, the business has the right to audit or check in with the third party. And that third parties should notify the business if they can't comply with the CPRA. So all these new requirements and obligations placed throughout the supply chain. And this is really shedding. If we were really focused on the obvious vendors, the service providers for purposes of CPA compliance, we're really focused on the rest of that supply chain. And there was a recent report issued by Osano that indicated, at least from those businesses that were part of the study, that an average business shared data with over 700 different vendors / third parties, which just kind of, and I don't know if how, I mean, that's part of the report. Sounds really high, but in my experience, there are a lot more than the business anticipates. I think that's kind of the across the board understanding. You just kind of get into who you're sharing data with, and once you really put it down, whether on a data map or in a separate spreadsheet, you can really see how that number can exponentially grow. And so getting a handle and getting all those vendors that are holding, again, just the ones that are processing personal data under control can be a chore and a big part of demonstrating compliance. And it's a very important one for purposes of managing risk. So some of the other things that I didn't mention, sub-processor permissions. A lot of these contracts already address it by just naturally, that's what a GDPR kind of influenced our contracts to read. Now it's actually started to become a requirement in the CPRA to require those the service provider does business with for purposes of processing the data, that they also are subject to the same rules and requirements. And as I mentioned, there are avenues for monitoring compliance and auditing the third parties and the service providers that are now mandated by the CPRA. So we're going to see a round of updates and revisions to the contracts we've already been updating and revising. And so it's just another area not to sleep on, this compliance part of it, because it is could prove to be a substantial one.
I just want to note really quickly before we go to the next slide, from a due diligence as well as from a business intake perspective, I am seeing through our clients many more requests to get information about the data compliance programs of a particular vendor. We weren't seeing that as often, but I more and more am seeing business development teams contact me and say, hey, we got this request, like we've never seen something like this before. And so, this isn't something that, I've been in this space for a while. 7 years ago, we would say things like this and people would be like, well, I don't see that out in the marketplace. But now you are seeing it out in the marketplace. You are seeing these requests. You are seeing this become a core part of business development and client intake and client management. So, I wouldn't be surprised if, within your business, if you, are a third party, are a vendor, wherever you are in the supply chain, you probably will start seeing more of these requests. And so, you need to, again, have the homework to abide by the request. Next slide. So the CPRA goes much farther than the CCPA, and one of the criticisms of the CCPA was there was not any specific resources or an agency created that would target consumer privacy and actually effectuate the CCPA. And one might argue, and yes, this last year with COVID, I'm sure that there were a lot of other places where priorities were set in the AG's office. That being said, there still is not a specific agency besides the AG's office that their whole mission is to enforce the CCPA. The CPRA rectifies that and creates the California Privacy Protection Agency. So there will be an agency that their entire mission goal is going to be to enforce this law. The rulemaking will start this year, and I think it'll be very interesting to see, because this is a brand new agency, what the composition of this agency looks like, who joins this agency in terms of leadership, what type of attorneys they bring into the agency. But I think this answers the question of, will the CPRA be enforced in a way the CCPA was not initially enforced? And I think the answer is going to be a resounding yes from I know our group, but also other privacy professionals. Their entire mission is going to be making sure that this gets enforced, and that they're doing it in a manner that makes sense. But I also think that there's going to be in the next couple of years, a lot of movement under the CCPA that will educate how this agency, goes about doing its business. So,
and if I may jump in there, in addition to helping to make that a reality, one of the things that's baked into this new law are requirements for people who are going to be part of this agency to have a privacy background. And so as we're kind of experiencing this shift in leadership with the AG's office, how it's impacting enforcement, the idea is to really move away from that. And how do you do that? You set up an agency that just has people who understand privacy and privacy compliance and are enforcing it. And that's their sole focus. Didn't mean to interrupt there, but that's just one of the big things that really stands out there.
So next slide, please. So I think a question, and I think I got all sorts of versions of this over the last, 2.5 months or so, since the CPRA passed, is the CCPA a lame duck regulation? Do I need to do anything? If I have done something, that I just waste a bunch of time and resources in complying with the CCPA? And I have to say that the answer is no, and that might not seem like that at this point in time, given that there's a new regulation going to go into effect on the horizon. But I think we have to look to the modifications over the last year. So setting aside the fact that the law, from all sort of outside optics, looks like it might not have been as ardently enforced as it could have been over the last year, and we could posit all the reasons why that was. The modifications, I think, really lasered in on something that I think is going to be an enforcement priority, and we sort of wouldn't say we've danced around it so far, but we've been talking about being able to demonstrate, if there's an opt-out request, for example, how you would respond to that opt-out request. And that is consumer rights. And, it's very easy to slap up a privacy policy on your website that says all these beautiful things about how, you're going to respond to consumer requests. And if they fill out this form or send in this email, that, you're going to begin that process. But actually having the workflows and mechanisms in place so that if you get a request, that you can track the entire life cycle, meet all the regulatory deadlines. In some instances, you might have multiple regulations, the CCPA, the GDPR, that have different deadlines for when things need to happen. That's a lot of work. And that requires a process that not only at a high level makes sense on paper, but whoever is handling that process within your company, maybe you've elected someone in customer service or another unit, they have to be able to understand that policy and implement it. Further, and I think this comes back to the right to delete information and requests that actually require specific activity to be taken by the company. If you commit to someone that you did something and actually technologically you cannot do it, I think that is also going to be a place where there's going to be problems for companies if there ever is an enforcement inquiry. Is, were people making requests, you were sending them really nice letters and other correspondence that their request was honored, but actually you didn't delete it or didn't have the means to really delete it. The other piece here that I want to highlight is, and I think that I think sort of generally the approach with consumer requests has been, I get one, I have to honor it. Well, that's not necessarily the case either. You might have a legitimate business purpose, a statutorily basically approved purpose for why you can keep certain information. The GDPR has allowances for this, so does the CCPA, as will the CPRA. So, if you have legitimate business purposes for why you are retaining certain information, that's something else that has to be built into that process. So you also don't want people who are in charge of responding to requests just to delete things or give away information if you have a reason why that request shouldn't be honored. The point of these consumer rights is to protect consumers, but also to provide explanation to consumers in instances where you may not be able to honor the requests. So I just want to point that out, that the modifications from last year were really focusing on, basically activating consumer rights. So if you have done the cosmetic piece, which, I understand might be logical because that's a very outward focused piece, now, given the CPRA, turning to the actual workflows and the processes and the training, like now is the time to make sure you attend to that ASAP, because that, again, why did the CPRA come back on the scene? The advocates behind it simply didn't think the CCPA was enough. So, if you hadn't done it for the CCPA, again, the CPRA is not going to become less onerous. It's going to stay how it is, or something else is going to be added on by the legislature or the voters of California. Because, if you are in this state or not, every year we have ballot initiatives. So we decide to be innovative and creative and add new laws. I would keep pace, as enforcement actions may emerge. Unfortunately, and this is one area that, in-house counsel as well as outside counsel like us look to for guidance, is what does enforcement look like? In Europe right now, there's been a host of enforcement from data protection authorities. So I can look at certain issues for my clients, whether it's cookies or other issues, and say, you know what, the Irish Data Protection Authority said this, or the Netherlands said that. So that's been helpful because it lets us know where these DPAs are going. Without that, in California, I can't say, hey, this happened last week, your business is doing a similar practice, let's adjust. But as enforcement actions come out, we will start to see sort of what the parameters actually are for enforcement, with the CCPA. But I think finally to note, you can't run away from this anymore. And I completely understand in the sort of categorization and hierarchy of needs of businesses that, while I love what I do and think it's the most important thing you can possibly do for your business, we often fall towards the bottom as privacy compliance professionals, but this isn't going away. We're seeing trends across the United States. We're seeing Brazil, Jamaica just even passed something that looks like the GDPR. If you thought we could run from this, no more. So, now's sort of the time to just accept that, you're going to have to build a compliance program that has some of these elements in it. Yes, it'll vary from state to state potentially, but as we look at various consumer privacy legislation across the globe, you're seeing 4 or 5 consistent things. Some of them might have some differences, but we are seeing trends, and you're not going to be wasting time, putting in the effort now for one, compliance regime, because these other ones that are emerging, we're just seeing so many similarities. So, now that we have sort of a larger sample size of laws, both globally as well as here in the US, it's a lot easier to say, look, committing to this makes a lot more sense because our global footprint or our domestic footprint, looks like this. Next slide. So if you haven't done anything, which, this is, no one has to admit if they haven't done anything, but if, haven't done anything yet for the CCPA, the CPRA is coming, it's coming in less than 2 years. So, just a couple things we recommend, won't get into details, happy to follow up, but data mapping, if you have no idea what your data flows look like, now is probably the time to get a handle on that. Your internal policies, I always think that you need to put your internal house in order before you put your beautiful external privacy policy up on your website. Training your employees. We are also, the 3 of us professionals that work on data breaches, and employee error is, very, very top of the list of things. And same thing with privacy issues. Sometimes it's not technical, it's not fancy. It was just an employee who made a mistake because there wasn't any training or resources to support them. Vendor management, Steve has talked about this. This is becoming even more important. And then finally, not just doing, cosmetic privacy things or even just handling the privacy side of the house, but also turning to security. And so if there are certifications or outside audits you can do with security firms, firms, because of the private right of action, I would heavily endorse, finding those professionals and having them assist you with, going through those qualifications with your business. Next slide. And turn back over to Steve.
As predicted, there have been a number of cases filed under the CCPA in court, including those that did not necessarily grow out of or arise from a data breach. And so we counted, there have been at least over 50 cases, many of them class actions, and they fall under three buckets. The first is the classic data breach that is anticipated by the private right of action section of the CCPA. And we also have cases that are based on privacy practices. A classic example involved Zoom, when there were transfers and uses of data that were not disclosed by the company. People had equated that with an unauthorized access to data akin to a data breach. So, we have the no notice of a sale or at the collection of data, in the data privacy practices bucket. And the third being miscellaneous references to the CCPA. And this could be for a number of reasons, whether it forms the basis for an unfair competition law claim or a Consumers Legal Remedies Act claim under California law, or it informs a duty of care that is owed to the handling of personal information. The big picture here to take away is that where standing in federal court in data breach cases is still an open question. There's literally a 11th Circuit decision that was just issued not too long ago. There's a split in the circuits on what's enough to demonstrate standing. That is entirely gone under the CCPA. So long as you meet the requirements of what it triggers a private right of action, you do not need to demonstrate damages or the amount of controversy to be able to proceed with your case. There's statutory standing that it's under the law, and that's just really a big picture. As the definition of what is personal information that can qualify a case expands, we expect that the number of cases to go up will go up as well. And in addition, we're going to see more defenses and creative arguments as these cases continue to progress in court. Next slide. And I believe that's for Christina to handle.
As we've discussed earlier, this is a trend, and I wanted to identify just a couple of states that might not be top of mind for, very progressive as it relates to consumer privacy, but, they are still looking at this actively. And much of this has been precipitated by COVID-19. There's been a lot of concerns and questioning about the collection of personal information in technologies and other systems that have come out. Work from home has really spurned conversation about, individual privacy. So as you can see, Washington, Florida, Virginia and Oklahoma, Minnesota, those are generally not jurisdictions I would have thought of a year ago of having active consumer privacy legislation being debated, but here we are. So I just want to point out that it's not just the Californias and the Washingtons and the New Yorks. I think that some of these states sort of stand out as being very progressive with privacy and security. You are seeing such a diversity of states and state legislatures and individuals bringing these bills and coalitions behind these bills that we just haven't seen before. So I know we're actively tracking these as a group, but if you do business in these states, I would certainly pay attention because they are implementing things that are much like the CCPA, are going to borrow from the CCPA, and are going to create much more heightened requirements than exist in those states today. Next slide.
And a common question is, what happens, like when is a federal privacy law going to take effect, or when is it going to gain traction? How will it impact the state laws that are already in place? And kind of just, there's lots of different opinions on it. The first being it might not happen this year, probably look into next year or even the year after before we realistically have a federal privacy law, which means these laws and the ones that pass in the interim are here to stay. And also that where California goes, the nation goes. And it's oftentimes even influence federal law and may set the standard that federal law might say, yeah, it's what California set out. and it will already have an impact on federal privacy law that may come in the future.
Yeah, I would not hold my breath for omnibus privacy legislation. There's a lot of other technology issues that with the new administration are taking precedence. So, if you were waiting for, Congress to give you one law to follow everywhere, I don't think that's going to be the case this session or likely next. So, while I understand that this hodgepodge of different laws, can be a little bit overwhelming, one of the things I always tell my clients is, well, then look for the highest level, sort of the highest watermark you can look for and go there. And so again, not that I'm here to hype the CCPA and its requirements, but if it is the most onerous in the US and other states are going to be sort of heading that way, it wouldn't be the worst idea to use the CCPA as you benchmark your compliance program.
Christina and Steve, excuse me, in the just few minutes we have left, and I know we're on our last slide with takeaways. We did have a question just a few minutes ago that I wondered if one of you could address, and it acknowledges that the CCPA has specific exceptions or exemptions for certain businesses, business size categories, whether it's a nonprofit, that sort of a thing. Are there similar and or different exceptions for the CPRA and who it sweeps up in its ambit?
I could start. It basically builds off the same definition, just there's some revisions to that definition and what businesses trigger the definition for a business under the CCPA. And so one such change is that the number of personal information of X consumers over a year triggers application. That number was 50,000 under the CCPA, has actually risen to 100,000 for under the CPRA. So that's good. But at the same time, there's another subsection that says if you derive 50% or more of your income from selling, then that's another trigger for the CCPA. The change there was they've made that selling or sharing. And so that kind of makes it, they've restricted the definition by amping up the standard in one point, and they've expanded it in another. And then the third is whether you make over 25 million in the past year. They just kind of clarified that. Otherwise, it kind of remains the same as it was under the CCPA. And if that answers the question, I'd be happy to take a stab at the first of our top 5 takeaways. And that one is that this process of data privacy, data protection compliance is a marathon and not a sprint. It's something to preach to the internal teams at your business, those seeking for a quick win. While there are some along the way, if you can look at it as a long-term engagement, a compliance process that needs maintenance and care over the long term, that will lead to success. And also helps to set expectations. Not going to reach everything 100% compliance, next week, but something that you can set milestones for and then demonstrate compliance with maybe no incidents or prompt attention to requests and the reduction in the number of times or the number of days it takes to reply to a request. So just if you take that long view, it'll help tremendously in terms of demonstrating compliance.
I know we're hitting up towards the hour, so I'm going to cherry pick my takeaways and I'm going to focus on 3 and 5. I cannot emphasize the number of requests I'm getting versus 2 years ago from my clients that are software as a service companies, third parties, vendors. They're getting, questionnaires, they're getting requests for production of documents internally, like they're getting all of these requests for things that they have never been asked for. And in some instances, that's how I have, new partners I work with is they're like, we just got this request. And so I think we need to do some things and we're able to assist, but also even businesses who've been doing this for a very long time, they're just seeing a change in the environment. And it's becoming a business requirement in a lot of instances to be able to demonstrate your compliance, or you are making in contracts or data processing addendums, you're making declarative statements that you've done certain things. And so again, it's not just a regulator. If you're going to make a affirmative declaration to a client that you are doing A, B, and C, and you actually aren't, that could also be a litigation risk and a breach of contract risk. And finally, one of the things that, I get the pleasure of working on is really cool ideas and really cool ideas that are going out for funding. And as part of that, the due diligence process, some of the traditional things, that would pop up, like intellectual property would be an example. Now you're seeing the same types of requests for data privacy. And what's been done by the startup or the business as it relates to data privacy. Are they aware of the regulations they're supposed to be complying with? If their roadmap takes them into a Brazil or Ireland or wherever, are they on top of the data privacy laws? So again, where I think this conversation was not from in a trenches perspective as embedded in day-to-day business, we're just seeing more of that. So again, I think there's more of the market is driving this, and making sure that you're ready to go if you get those requests.
Thank you, Christina and Steve, and I would just amplify those takeaways as well. We see privacy as important, not only for an enforcement and a kind of risk avoidance litigation obligation, but also as a competitive issue. I think in this marketplace, increasingly consumers are looking for companies that abide by these requirements, and certainly in the engagements that we have where we are advising on due diligence for private equity or other types of entities. This is now a staple of their due diligence questionnaire. And so there are myriad reasons why this is important. That's not lost on the audience who took the time out of their busy schedules to join us. And so for that, we want to thank you. We are at the top of the hour. I think we've answered all the questions that have come along the way. And for those, I want to thank you and thank you for your time. And if there aren't any other questions, thank my colleagues, Christina and Steve, for a terrific job. And we will follow up. A few of you asked about getting copies of the presentation. We will make those available afterwards offline. And with that, thank you for your time and have a great rest of the day.